accordance with the principle of fundamental justice. Before you're gonna go in section 1 analysis, I have written everything here. What is principle of fundamental justice? Same as Oak test. See? So he gonna read section 1. Okay. It's very important, my friend. If you are confused, tell me. Okay, read. Okay, read. Okay, computer guys, so we are talking about section 7. If 2A is going to be infringed, next issue is whether law is 2A is justified under section 1. If 2B is infringed, the next issue is whether section 1 is 2B is justified under section 1. Section 7, life, liberty, security is going to be infringed. The next issue is, can you read? The next issue is whether, the next issue, can you read louder?
The next issue is whether the deprivation is in accordance with the principles of fundamental justice.
So what is principle of fundamental justice? Same as Oak's test. 4 steps. Same as Oak test. Can you read?
Canada Attorney General versus Bedford. Before considering sufficient importance objective.
See, sufficient important objective, same thing. Second one.
Rational connection, minimum impairment, gross disproportionality.
This is a key point. If you will miss this point, if section 7 would be in an exam, if you will not go in accordance with the principle of fundamental justice, 0 out of 10.
So, sir, what is the difference between this additional step and
0% difference?
Okay.
But examination point of view, we have to go into, before we're gonna go into section 1 analysis, we have to go in fundamental justice. 0% difference.
So we will write the same thing under the 2 things. Same thing.
Yes, yes. Then again, must go to section 1 analysis. Again, I'm telling you, every time in my class, not every time, sometime, people always miss, oh, it's a fundamental justice. We do not need to go into section 1 analysis. Must go, same step. Section 7, life, liberty. In a given scenario, liberty is going to be infringed. Violation of the liberty, 10 years jail. The next issue is whether law is in accordance with the principle of fundamental justice. Sufficient important objective, 10 years jail, whatever. Rational connection, minimum impairment. Then again, whether section 7 is justified under section 1. Same steps. I have one question, just one question. Computer guys, I need your eye contact. I need an answer. If law is not accordance with the, do not write. If law is not accordance with the principle of fundamental justice, what's that mean? If agree, life is going to be infringed, liberty is going to be infringed, or security is going to be infringed. But law is not accordance with the principle of fundamental justice. What's that mean? Law is saved or law is not saved?
No.
Law is not saved. If law is not accordance with the principle of fundamental justice, it means law is not saved. Can ever be justified under section 1? Yes or no?
No.
Oh, beautiful. Beautiful, yeah. Oh, beautiful, yeah. I get more energy. If you're gonna pay me attention, I get so more energy, more and more. Seriously. If you will answer left and right, then I always tired. If you need, like, see, if law is not accordance with the principle of fundamental justice, cannot ever be justified under section 1 because it's the same steps. If law is accordance with the principle of fundamental justice, always would be justified under section 1. Okay.
But sir, in both instances, we still mention both steps. So even though we've done according to fundamental justice,
if you will miss one of them, you're gonna lose at least 10 marks.
Okay. So we'll say, okay, fine. For example, law is not in accordance with fundamental justice, but we'll still go to section 1, do it again, and say it's still not covered. Okay, thank you.
Okay, one more thing.
Can I ask one?
Yes, man.
Maybe it's a silly question. What is principle of
question is never silly, man.
What is principle of fundamental justice?
Same as Oak test. Sufficient important objective. If you will read just for 1 second, maybe I can be wrong. Okay. Reference is very section 7. If you're gonna read Peter Hogg book, chapter is 43. I do not have a book.
Oh, I'll be going through your notes. I won't read.
No, I'm gonna in my class.
Hard to read.
It's charter, huh?
The book's hard to read.
It's very hard. In my, that was my mistake. I didn't carry the book. Whatever I'm telling you, I always show the book, reference with the book. Even even one word, everything wording, I pick up from the book. If you're gonna say, Aamer, I do not agree with you. I do not agree. You have a right to cross-exam. I'm gonna show you the book is right here. In my regular class, it was my mistake. I forgot. I left my book in a home. Right? Now, one more thing. Again, I am telling you one more thing. Section 15. Computer guys, again, you're gonna lose 10 marks. Section 15, subsection 1, listed or analogous ground. There are 4 analogous ground. 15, subsection 1, listed or analogous ground. The next issue is whether law is justified under 15, subsection 2. Before you're gonna go into section 1 analysis.
Sorry, could you repeat it?
Section 15, subsection 1, listed or analogous ground, may be listed from or maybe analogous ground. Once you can establish 15, subsection 1, the next question is within the criteria of R versus CAP, within the criteria of R versus CAP, KAPP 2008, whether law is justified under 15, subsection 2. What is section 15, subsection 2? Okay, guys, can you write listed ground? Can you write analogous ground? 4 analogous ground. Can you write citizenship? Citizenship, Andrew versus Law Society of British Columbia. Citizenship. Citizenship, Andrew versus Law Society of British Columbia. Andrew, ANDREW, Andrew versus Law Society of British Columbia. Number 2, marital status. Marital. You are married. You are not married. Based on marital status, no one cannot make a discrimination in whole Canada. Marital status case was Myron, M-I-R-O-N versus Trudel. Trudel, T-R-U-D-E-L, 1995. Third is sexual orientation. Sexual orientation. Sexual, S-E-X-U-A-L, orientation, O-R-I-E-N-T-A-T-I-O-N. Sexual orientation. Vrind versus Alberta. Vrind, V-R-I-E-N-D. Vrind versus Alberta. Last one is aboriginality residence. Aboriginality, Aboriginal people. Case was Corbier, C-O-R. Aboriginal residency. Case law is Corbier, C-O-R-B-I-E-R-E versus Canada.
C-O-R-B-I-R-E.
Yeah.
So can you please repeat the last case?
C-O-R-B-I-E-R-E.
Sir, can you repeat the case for sexual orientation, please?
Sexual orientation is Vrind, V-R-I-E-N-D.
Versus?
For the aboriginality, it's Corbier versus
Canada.
Sir, Vrind versus Vree versus
Alberta. Alberta, 1998.
May I get the first one, please?
First one is citizenship. Andrew versus Law Society of British Columbia. Citizenship. Okay, my friend, it's a real case, even real case in my personal real life. Not that was a real case, but I tried to establish the case. In a real picture, my mother lives with me. She's 83 years old. My mother, she is 83 years old, right? How old is she?
83.
83. So she is taking benefit